With regard to a search of a home in the state of Nevada, first, if the police have a search warrant, then they can come in and search your home. Usually, they will arrive with the search warrant in hand, but they won't always necessarily show it to you. Often when police are coming with a search warrant, it's going to be a quick knock at the door, and if you don't answer, the door may just get knocked down. But just because the police have come into your home, searched your home, and claimed to have a warrant, it doesn't necessarily mean A, that they had the warrant, or B, that it was a lawful warrant. When the police apply for an application to search, they have to actually prepare an affidavit that details all the facts relevant to their desire to search. They have to present that to a magistrate who then has to make an independent determination as to whether the affidavit is sufficient to justify the intrusion into the home. Sometimes, of course, a bench officer is supposed to thoroughly review the affidavit. Sometimes, when defense counsel has an opportunity to review the affidavit, the defense attorney becomes aware that statements in the affidavit are actually not true. Sometimes a bench officer may misread the affidavit or may not read it thoroughly, and they'll sign it. And another officer who reviews the search warrant will find that the information contained in the affidavit was not sufficient to justify the intrusion. Or if there are misstatements in the affidavit or untruths, those could be redacted, and a magistrate would evaluate after the redactions whether or not the affidavit was sufficient to justify the issuance of the warrant. So there is a substantial area in law having to do with motions to quash or traverse a search warrant, and it can be a very ripe avenue for success for a defense attorney to either have leverage to negotiate a better deal for their client, or ultimately succeed in getting a search warrant quashed and the fruits thereof suppressed as evidence. Sometimes the police will show up at your home and they will ask for permission to search. This would be called a consensual search. And you don't have to give consent to a search of your home. Sometimes if there are children involved, the police will say things like, look, you can sign here and give us consent, but if you don't do it, we're going to search anyway. We're going to go to a judge. And if you sign here, we'll let you keep your kids. But if we have to go and get a search warrant, then we're going to call, to have your children removed from the home. Ultimately, obviously, if that's the situation, the individual needs to weigh it out and decide. But as a matter of law, you don't have to consent to a search of your home, which is considered to be the most invasive intrusion that law enforcement could do to come into your home. So if there's a search warrant, if there's consent to search, sometimes if someone is fleeing from law enforcement and runs into a home, the police have the right to go into a home to chase after them. If there's a domestic violence call or a call that suggests that there may have been some violence in the home and that someone might be injured, there's a limited exception that allows law enforcement to go into the house to do a safety check on individuals to make sure no one's hurt. But ultimately, if the police have entered your home, the issue of did they have the right to do so always comes up, and it can be a ripe avenue to explore for potential avenues to suppress evidence and ultimately get your case dismissed. I'm attorney Michael Becker with the Las Vegas Defense Group. If you or a loved one has been charged with a criminal offense in Las Vegas or throughout the state of Nevada, trust in me and my legal team to get your case dismissed or otherwise negotiate a resolution that causes minimal harm to you in your future.